Hi, I'm Kent Berk. I'm an attorney at the Scottsdale, Arizona firm of Berk and Moskowitz, where we handle real estate and other disputes in Arizona. I'm going to record here a video PowerPoint presentation regarding Arizona's anti-deficiency statutes. This is an update to an earlier PowerPoint presentation that I did a couple of years ago, and this one is based upon recent updates in Arizona law and recent cases decided by the Arizona Court of Appeals that clarified and interpreted the statutes. Of course, this presentation is just a general overview, is for general informational purposes only. It's not legal advice. If you have a legal dispute involving real estate or a foreclosure or what might involve Arizona's anti-deficiency statutes, please consult an attorney. Each case is different. So let me just give you a quick overview of what I'm going to talk about today, and that is basic terminology, what constitutes qualifying property under Arizona's anti-deficiency statutes, the two different types of foreclosures in Arizona, how the anti-deficiency statutes apply in each type of foreclosure, what happens to second loans. So first of all, terminology. Some important terms to understand. There are basically two components to a foreclosure: the promissory note and then the deed of trust. The promissory note is the borrower's promise to pay a certain amount of money, and then the deed of trust is the document basically that gives the lender the right to foreclose on the collateral, the real estate, if there's a default on the promissory note. Those obligations, the promissory note and the deed of trust, are separate and independent. The foreclosure is the process by which the lender has the property sold to satisfy in whole or in part the amount due under the promissory note. And of course, Arizona has two types of foreclosures. A deficiency is the difference between the amount due on the promissory note and the amount for which the property sells in foreclosure, or the fair market value of the property at the time of foreclosure, whichever amount is greater. So if the property sells at the foreclosure sale for $80,000, but the true fair market value of the property is $100,000, the borrower would be entitled to a credit against the promissory note, against the debt, for the $100,000 in any subsequent action to recover a deficiency. And the anti-deficiency statute is the law that in certain limited circumstances that I'm going to explain in detail in a minute, the lender is precluded from going against any other assets of the borrower to satisfy the amount of the debt in the event of a deficiency. In other words, it's what's called a non-recourse loan, such that the lender can only go against the property pledged under the deed of trust and no other assets if the anti-deficiency statute applies. So when the anti-deficiency statutes do not apply, again, the obligations under the promissory note, the debt, and the deed of trust and the collateral are separate. That means the lender's foreclosure on the collateral does not extinguish the debt if the anti-deficiency statutes don't apply, and the lender may pursue the borrower's other assets unless the sales price or fair market value of the property at the time of foreclosure is equal to or greater than the debt, or there's no deficiency. So there's 5 key questions in analyzing whether the anti-deficiency statutes in Arizona apply. First, what is the size of the land? Second, what's the type of the property? Third, what's the use of the property? Those 3 things determine whether the property is qualifying property under both of Arizona's anti-deficiency statutes. Fourth, what's the type of foreclosure? And fifth, what's the type of the loan? Now let's discuss those in more detail. The size of the land. Arizona's anti-deficiency statutes only apply to property that is 2.5 acres or less. If it's more than 2.5 acres, the property is not qualifying property, and both of Arizona's anti-deficiency statutes are irrelevant. Secondly, what's the type of property? The anti-deficiency statutes only apply to a 1-family or 2-family dwelling, not raw land, commercial property, or agricultural property. Only residential, single-family, or 2-family dwellings. Third, what is the property used for? The property must be used or intended to be used as a dwelling. The Arizona Court of Appeals recently decided a case that a home that was under construction by the borrowers, even though it was not yet used as a dwelling, Arizona's anti-deficiency statute did apply because the borrowers intended to occupy the dwelling once it was completed. The home does not need to be used or occupied by the owner or borrower. A tenant is okay. A lot of people misunderstand that Arizona's anti-deficiency statutes only apply to owner occupants. That's not true. Fourth, what is the type of foreclosure that the lender is pursuing? A trustee sale or judicial foreclosure? And Arizona has two types of foreclosures: a non-judicial trustee sale and a judicial foreclosure. A trustee sale is a process where the lender issues a notice of sale and auctions the property. They have to give notice at least 90 days before the trustee sale, and the foreclosure sale or the auction usually takes place at the courthouse steps. If it's a trustee sale, if the property is qualifying property, it's 2.5 acres or less, a 1 or 2 family dwelling, and the property is used or the borrower intends to use the property as a dwelling upon completion by someone. If those three requirements are satisfied, then the anti-deficiency statute applies and the foreclosing lender may not pursue a deficiency. The type of loan makes no difference if the foreclosure is by a trustee sale. The determination of whether it's qualifying property likely is determined at the time of the trustee sale. The second type of foreclosure is judicial foreclosure, whereby the lender files a lawsuit. It proceeds just like any other case. It's rarely used because it takes a lot more time and is a lot more expensive than a trustee sale. But if the lender does pursue a judicial foreclosure, then we need to also know whether the loan that the lender is foreclosing on is a purchase money loan. A purchase money loan is a loan used to acquire or improve the property that's provided in the deed of trust. So the borrowers obtaining a loan that they use to actually acquire a completed dwelling, of course, would be a purchase money loan. A construction loan is also a purchase money loan where the borrower takes out a loan from the bank to build the dwelling that the borrowers intend to occupy. Let's look at some other issues, whether these are purchase money loans. A straight refinance of a loan that was originally a purchase money loan where no money is taken out, yes, that qualifies, the Arizona Court of Appeals has said, as a purchase money loan. Another situation is where there's a refinance with the borrower taking money out of the loan. To the extent the borrower takes money out of the loan for other purposes other than to improve the property or other than for acquisition of the property, the money that's taken out is not protected by the anti-deficiency statute. In other words, the purchase money part and the non-purchase money part are segregated. So just to summarize, in judicial foreclosure, the anti-deficiency statute applies if the property meets 4 criteria. If it's 2.5 acres or less, a 1 or 2 family dwelling used as a dwelling by someone or intended to be used as a dwelling by someone, and it's a purchase money loan, a loan used to acquire the completed dwelling, or a construction loan used to build a home that the borrowers intend to live in. If those 4 criteria are met, then the anti-deficiency statute applies and the foreclosing lender may not pursue a deficiency. It's unclear whether those four criteria are determined at the time of the deed of trust or at the time of the foreclosure. So what about second loans? Basically the same analysis applies. If the lender forecloses by trustee sale on qualifying property, then the second lender may not get a deficiency, may not go after any other collateral than the property itself. If the second lender forecloses by judicial foreclosure, then we need to know whether the property is qualifying property and whether it's a purchase money loan. If it's qualifying property and the second loan is a purchase money loan, then the anti-deficiency statute applies and the foreclosing lender cannot go after any other collateral. But if the second loan is not a purchase money loan or it's not qualifying property, then the second lender can collect a deficiency or can waive the collateral and simply file a lawsuit to collect on the debt. In summary, Arizona's anti-deficiency laws only apply to qualifying property. Property has to be 2.5 acres or less, a 1 or 2 family dwelling, used or intended to be used by someone as a dwelling. If it's a trustee sale, the type of loan is irrelevant, whether it's a purchase money or non-purchase money loan. If it's a judicial foreclosure, the borrower is only protected if it's a purchase money loan. So in conclusion, be aware the laws may change. There will likely be additional cases issued by the Arizona Court of Appeals and or the Arizona Supreme Court that could change the current status of the law. Read your loan documents, because in certain cases the loan documents can change the application of the anti-deficiency statutes. Most importantly, in the loan documents the lender can waive the right to collect a deficiency. It's a complicated multi-step process, and again, this presentation is just a general overview. Whether the anti-deficiency statutes apply depends on many factors. If you have a case involving potential application of the anti-deficiency statutes, consult with an attorney. There's still many unanswered questions under Arizona's laws. Thank you for your time. If you have any questions, you can contact us through arizrealestatelaw.com, our website, or give us a call at 480-607-7900. Thank you.